Hello guys, welcome back to my channel. Let's continue chapter 3 or unit 3, whatever you may call it. We were doing arbitration. In the previous video we saw the meaning, process of arbitration. In this video I have to begin from types of arbitration. First is domestic arbitration, an arbitration with Indian parties where the place of arbitration is India and rules applicable are Indian. So domestic means in that area only, in the local area. Indian parties, place of dispute or place of resolution of that dispute is a region in India. The rules applicable in that area, अगर इंडिया ही region है तो rules भी Indian ही apply होंगे. Foreign arbitration is where proceedings are conducted in a place outside India and award is required to be enforced in India. So, proceedings are taking place outside India, but the verdict has to be enforced in India only. Verdict आप outside India दे दो, लेकिन उसको enforce India में ही होना है. Ad hoc arbitration is governed by parties themselves without recourse to a formal arbitral institution. It may be domestic or international in character. Ad hoc means by the parties themselves. Parties themselves will get or will appoint an arbitrator. They will not go to a court to ask for them to appoint an arbitrator. कोर्ट के पास नहीं जाएंगे, कोर्ट से नहीं बोलेंगे कि आप मुझे एक आर्बिट्रेटर अपॉइंट करके दो, अपने आप ही सारा काम कर लेंगे. Institutional arbitration is where parties select a particular institution which in turn takes arbitration forward by selecting an arbitrator and laying out the rules applicable within an arbitration, example, mode of obtaining evidence, etc. There are several institutions for doing this. Examples: the London Chamber of International Arbitration, which has its offices across the world, including New Delhi, India. So, institutional arbitration is when the people or the parties to the suit, they select a particular institution and they go and ask that institution to appoint or to select an arbitrator for them, to select an arbitrator for resolution of the dispute that is between them, and in turn that institution also decides that what all rules will be applicable for that arbitration process to take place efficiently. Statutory arbitration is which is mandatorily imposed on parties by operation of a particular law or statute applicable to them. For example, the Defence of India Act 1971 is one such legislation that mandates a recourse to arbitration in case of any dispute arising within the Act. Statutory arbitration is a sort of process which is mandatorily put upon the people. They have no other option rather to accept the process or the arbitration proceedings as and how it is mentioned in the particular Act. International commercial arbitration is in which at least one of the disputing parties is a resident or body corporate of a country other than India. If it's international, that obviously means outside India. One of the party to the dispute has to be a resident or a body corporate of a foreign country. Arbitration with government of a foreign country is considered to be an international commercial arbitration. Now you see, if a person is of outside India, agar a person is resident of a country not India, so you can't contact him directly for arbitration. वहाँ की गवर्नमेंट की भी परमिशन या वो पर्सन जो है वो अपने गवर्नमेंट को भी इन्वॉल्व करेगा, क्योंकि तब उस गवर्नमेंट की रिस्पॉन्सिबिलिटी होगी उस पर्सन पे, एज ही इज द रेसिडेंट ऑफ दैट नेशन. इसीलिए तब आर्बिट्रेशन ना सिर्फ एक पर्सन के साथ होता है, बट इट इज ऑल्सो विद द गवर्नमेंट ऑफ अ फॉरेन नेशन. This form of arbitration has been defined specially under section 2 subclause 1 subclause F of Arbitration and Conciliation Act 1996. So, international commercial, please remember, international commercial arbitration is mentioned in which section of which act? Section 1F of Arbitration and Conciliation Act 1996. An overview of laws on arbitration. The Arbitration and Conciliation Act is the relevant legislation that governs process of arbitration in India. Statute provides for an elaborate codified recognition of concept of arbitration, which has largely been influenced by significant movements of judicial reforms and conflict management across the world. So this Arbitration Conciliation Act is the appropriate legislation that gives out or that elaborates that how arbitration process will be carried out in India. It provides for the elaborated version of code that needs to be followed. What is arbitration? What procedures need to follow in that? And what all significant movements or precedents of judiciary that are influencing the concept of arbitration in this act. In this regard, a special reference must be made to an international convention entitled United Nations Commission on International Trade Law, Model Law on International Commercial Arbitration 1985. So this is an international treaty, which is United Nations Commission on International Trade Law, Model Law on International Commercial Arbitration. After the birth of this, United Nations General Assembly recommended that all countries must give due consideration to the said model law in order to bring uniformity in law and practice of international arbitration. Indian Arbitration and Conciliation Act is similarly modelled on unilateral model law. So, when the United Nations General Assembly came up with this international treaty or convention, they urged all the countries to give a consideration. See, these things are not completely binding on each and every country of the world. So they can only give they can only give a suggestion, or they can only urge the countries to consider what they have passed. So they gave a suggestion, or they urged the countries to consider this international arbitration, so that in all over the world there is some sort of commonness or uniformity in how the arbitration process is carried on. And the Indian Arbitration Act, which we read about few minutes before, that is also on the lines of this United Nations model law. Arbitration Conciliation Act 1996 repealed several pre-existing arbitration statutes such as the Arbitration Act 1940, the Arbitration Protocol and Convention Act 1937, and Foreign Awards Recognition and Enforcement Act 1961. Thus, arbitration has for long been a part of Indian legal system. So, various years, various acts have been repealed, and then we came with the Arbitration and Conciliation Act. This act has ushered a new era of dispute resolution for domestic and commercial legal issues. On these lines, Supreme Court of India has also affirmed that Arbitration and Conciliation Act was introduced in order to attract the international mercantile community. Mercantile means the businessmen. So this act was basically introduced to attract the international community, so that now your disputes will not be taken up to the courts, but you can solve it through arbitration. Because arbitration can be used, it's a method that can be used to resolve the disputes for personal purposes, for civil matters, for domestic matters, or for commercial purposes. Commercial related disputes. Supreme Court has thus emphasized that Act should be interpreted and applied keeping commercial sense of dispute in mind. Konkan Railways Corporation Limited versus Mehul Construction Company. Now it's your homework. Just search on Google, type this case name and search for the summary of it. If you type this and they will give you, the Google searches will give you the bare act, that you may not be able to understand what it's written or what it's trying to tell. So write down the case name and then write down summary. Then various websites are there that may provide you with a summary of this case. So court said, the Supreme Court has said that if through this act we are inviting the international business community, then it is important that act has to be interpreted, implemented, keeping the dispute in mind. Commercial sense of dispute. Whatever the dispute is, what would be the commercial arenas of that should be kept in mind, and accordingly the verdict or accordingly the act should be provided. Glossary. Now glossary, arbitration agreement is whereby parties agree to submit their present or future disputes to arbitration. Whatever the dispute is, sometimes while at the time they are making the contract, they are agreeing to some terms and conditions in the contract, they put down this condition also that whenever in future if there is a dispute between us, we will not go to court, we will go to the arbitration method to solve that dispute. So that is, I am deciding that my future dispute will be solved by arbitration. And if at present we are having a dispute, we then now mutually decide that our present dispute we will get to resolve by arbitration. So it can be present or future disputes. This may be in writing or via other means of communication. Court referral to arbitration. If a party to dispute approaches the court despite presence of an arbitration agreement, the other party may raise a claim before the court. Means earlier both the parties have agreed that if in future there is a dispute, we will go to arbitration for the resolution of that dispute. But now when the dispute has arisen, one party has gone to court. He has not approached the arbitration process, but he had directly gone to the court. So now the other party can raise a claim against that first party, that why irrespective of that we have agreed for arbitration earlier, why have you violated that term of contract and now why are you in the court? Court then must refer the dispute back to arbitration if it has been previously agreed by the parties. And now, because of the claim by the second party, arbitration is also considered at equal terms as the verdict of a court. We have read this earlier. So the court will then refer the matter back to the arbitration process because earlier both the parties have mutually decided that they will resolve the dispute through that process only. This method of initiating arbitration is known as court referral to arbitration. And if the person says that, okay, we want the court to decide who will be the arbitrator, then the court can select the lawyer or whatever to act as an arbitrator in the matter. That can happen. Statement of claim. Initial documents filled by claimants enlisting the issues raised to be resolved in an arbitration. Means these are my details or my documents or my claims which I need to be resolved within this procedure. Counterclaim. Respondents reply to the claim presented by claimant. Setting aside of an arbitral award. An arbitral award rendered in an arbitration may be struck down or invalidated by the courts. Grounds of such are limited to incapacity of a party to enter into arbitration agreement in the first place, improper appointment of arbitrator, dispute falling outside the terms of arbitration agreement, bias on part of arbitrator, award violating public policy at large. So it is very important that we take care of the public policy of public order, of peace. So if any of the verdict which is given by an arbitrator is violating public policy, then that has to be invalidated or struck down by the court, and that is setting aside, that I've set aside what the verdict you have given because it's not at par with the standards. So grounds can be the person itself is incapable of giving the verdict, it's outside the jurisdiction of the matter, we are having business related dispute, the parties have appointed the arbitrator who is a great expert in lawyer but doesn't know ABC of business. So that is wrong. The person is not competent to sit over there and dispute is falling outside the jurisdiction. Also, if the parties themselves are not capable to enter into the arbitration agreement, then also the court can set aside the award. अगर पार्टीज ही केपेबल नहीं है लेकिन पूरा प्रोसीजर हो गया, आर्बिट्रेटर ने अवार्ड दे दिया, तो शुरुआत से ही वो चीज़ गलत हो गई, इसीलिए कोर्ट उसको अवार्ड को गलत मान सकता है. नाउ एडमिनिस्ट्रेटिव ट्रिब्यूनल्स. 42nd Amendment Act added Articles 323A, 323B to the Constitution. These empower Parliament to set up tribunals for adjudication of specialized disputes. Now please remember, I always say whichever article, wherever given, learn it. Underline it in the book and learn it. 323A and 323B inserted, and they gave the Parliament power to set up tribunals so that disputes can be resolved. Tribunals are specialized. They deal with a certain matter. If it is a consumer redressal tribunal, it will deal with the consumer disputes. किसी ने cheating करी, किसी ने adulterated सामान बेचा, so that all disputes will go to consumer redressal. That way, there are specialized tribunals which are set up for particular purposes. Their jurisdiction is limited. The range of disputes mentioned in Constitution refers to disputes pertaining to service conditions of government officers, collection and enforcement of tax, industrial and labor disputes, matters concerning land reforms, election disputes, sealing on urban property, and production, procurement, supply, distribution of foodstuffs or other essential goods. The 42nd Amendment Act assured the era of tribunalization of Indian judiciary, means under Indian judiciary, some other bodies were set up that were tribunals. So, tribunalization took place. Further, enactment of Administrative Tribunals Act 1985 took constitutional objective further and set up the Central Administrative Tribunal and State Administrative Tribunals. So, earlier there were various tribunals which were set up for adjudication of specialized disputes, and we had read about what those different disputes can be for which the tribunals were set up. Now, adding to this, Administrative Tribunals Act, which was enacted and passed in 1985, that also established some administrative tribunals, some at the state level and one at the country level. Then the CAT, that is Central Administrative Tribunal, was set up pursuant to Act of Legislature in 1985. Tribunals exercise jurisdiction of service matters of employees covered by it. Whatever matters or whatever jurisdiction they are given, they are entitled to deal with that matter only. The appeals against orders of administrative tribunals lie before the division bench of concerned high court. जिस भी स्टेट में वो ट्रिब्यूनल था जिसके ऑर्डर के अगेंस्ट अपील फाइल की गई, so that will go before the division bench of the high court of that particular state. Tribunals are procedurally flexible, and this flexibility increases their efficiency. Administrative Tribunals Act allows a aggrieved person to appear directly before the tribunals. Overall objective is to provide speedy and inexpensive justice to litigants. See, why we are establishing these bodies under judiciary? Because already there is a huge burden of cases on Supreme Court and High Courts, if we see, because of continuously delaying the hearings. So, these bodies were set up with the objective that people will get speedy justice, the cases will be resolved in a short period of time, and also the pendency of the higher courts will reduce. So the people can directly present themselves before the tribunals, they can get speedy justice, and also that whatever fees or whatever things they are getting done to get justice or to appear before the court, that is affordable. If they go to a higher court, High Court or Supreme Court, lawyers charge very high fees for appearing for a day or for appearing for hours. They are really expensive. Everybody can't afford it. Since government is a major litigant in courts and government-related litigation has increased in delay and pendency of litigation, such tribunals over the past 2 decades have significantly contributed in supplementing the role of courts in adjudication of service disputes. Now, service disputes of employees of government. So, obviously, if government is a party, that is, if government is the litigant in the court, because of, I will not say because of the government, but government related anything, we say, no, sarkar ka kaam hai, it will take time. Why? So, that thing happens, government is a litigant, and because of that, tribunals, because of that, there is the delaying of the hearing and cases are pending in the courts. So to manage that situation, as I have already said before, these tribunals were set up so that in a shorter period of time and at an affordable resources or price that the people can afford, tribunals are of great help. This has been explained by 7-judge bench of Supreme Court in L. Chandrakumar case, where it has held that tribunals would not take away the exclusive jurisdiction of courts and their decisions could be scrutinized by division bench of high courts. So the thing that we learned before, it was said in the Supreme Court judgment of L. Chandrakumar, wherein it was held that tribunals cannot take away the power or authority or the jurisdiction that the higher level courts have. Okay? And if you want, you can always and anytime you can scrutinize the verdict that the tribunals have given. So their decisions are subject to scrutiny, that is subject to review. If you want to review it, you can. But it will not take away the exclusive authority or power that the higher level courts have, so don't worry about that. One may also note that these administrative and state tribunals are not an original invention of Indian political and legal system. Such tribunals are now well established in member countries of European Union and United States. So it's not the new or it's not that Indians have invented this tribunal system, but it was well established before India had got it in various nations of European Union and US. Next video, mediation and conciliation.